Welcome to the History, Law, and Justice Podcast. I'm your host, Michael Buckner, a lawyer and amateur historian. I will explore with you legal issues affecting governance, society, and culture of the United States and other civilizations, both past and present, using history as my guide. Before we begin the episode, be sure to subscribe to our YouTube channel. Also, you're invited to share your thoughts on today's topic or anything dealing with history and the law in the comment sections below or on our social media platforms. The May 14, 2020 decision of the full United States Court of Appeals for the Fourth Circuit allows a lawsuit to continue that alleges U.S. President Donald Trump is violating the Constitution's Emoluments Clause. The case, which is called Citizens for Responsibility and Ethics in Washington versus Trump, will now head back to United States District Court for the Southern District of New York for further proceedings. The case centers on how the term emoluments is defined. In today's episode, we explore the constitutional provisions relating to emoluments and how that term was interpreted and applied to federal elected officials, including the President of the United States, in the early history of this country. The Constitution actually has two emoluments clauses, one foreign and the other domestic. The Foreign Emoluments Clause can be found in Article 1, Section 9, Clause 8 of the Constitution. That clause provides that no person holding any office or profit or trust under the United States shall, without the consent of the Congress, accept of any present, emolument, office or title of any kind from any king, prince, or foreign state. The Domestic Emoluments Clause can be found in Article 2, Section 1, Clause 7 of the Constitution. And that clause states that the President shall, at stated times, receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them. Some legal experts interpret the term emolument as meaning anything of value, whether it be monetary or non-monetary, from a foreign, federal, state government entity that is received by a business in which a president of the United States possesses a financial interest. So the question is, does that text or the history of the Emoluments Clause suggest that a president is prohibited from receiving any benefits that he or she may have in a business entity that derives from interactions with a foreign, federal, or state entity or some business operation affiliated with such governments? Well, let's examine the founders' intent behind the Emoluments Clause. When the United States was established, and continuing through at least the first 100 years of the nation's history, an emolument was a characteristic of a federal office and not that of a private enterprise. Well, how do we know that? Well, in the early history of the United States, the federal government followed contemporary practice and English precedent to compensate most federal employees only by the fees for services rendered by that person, or through commissions and other privileges and benefits that they received. Later, in 1850, the United States Supreme Court, in the case of Hoyt versus United States, described an emolument as every species of compensation or pecuniary profit derived from a discharge of the duties of the office. Further, in its 1867 opinion in United States versus Hartswell, the court noted that a federal office is a public station or employment conferred by the appointment of government. The term embraces the ideas of tenure, duration, emolument, and duties. The Foreign Emoluments Clause was adopted by the Constitutional Convention in the context of the custom of European sovereigns at the time. Under that custom, upon the conclusion of a treaty negotiation, a European sovereign would bestow presents such as jewelry or other gifts upon the minister of the other nation. Likewise, when that minister concluded his diplomatic mission, a European sovereign of the host nation would also provide or bestow gifts upon that departing minister. The debate concerning the domestic emoluments clause focused on the compensation of the president. Although there were some founders, such as Benjamin Franklin, who believed the president should not receive a salary or stipend for his services, the Constitutional Convention voted for the president to receive a fixed compensation while in office. Delegates such as Franklin and John Rutledge then proposed that the president be prohibited from receiving any other emolument from the federal government or the states. According to Delegate Alexander Hamilton in the Federalist Papers, the domestic emoluments clause was to guarantee the president's independence, and that for his services as president, he was to receive only the forms of compensation and other benefits as designated in the Constitution. However, the Constitutional Convention's final product did not explicitly address the financial compensation a president could accumulate from his private dealings. After the ratification of the federal Constitution and the election of the first crop of presidents of the United States, early office holders maintained their private businesses and regularly earned significant income from transactions with foreign entities. For example, the nation's first president, George Washington, continued to operate his plantation at Mount Vernon through the oversight of his nephew. President Washington's business exported various products, including flour and cornmeal, to foreign countries and territories, including Great Britain, Portugal, and Jamaica. Likewise, the third, fourth, and fifth presidents of the United States, namely Thomas Jefferson, James Madison, and James Monroe, all operated plantations that grew, among other things, tobacco during their times in office. According to available records, these businesses followed the common practice started in colonial times and continued through the early 1800s by exporting tobacco to Great Britain. Further, it is likely federal or state government-owned or affiliated entities may have been among the customers of the farms and plantations owned and operated by the early presidents. Based on the business practices of 4 of the first 5 United States presidents, it will be logical that a legal or other formal complaint or objection would have been made at that time if the founders of the Constitution had intended for the emoluments clauses, whether it be the foreign or domestic, to bar benefits arising from a president's private business dealings with a foreign, federal, or state entity. Eventually, it will be up to the United States Supreme Court to provide us with an answer to this fascinating question. You're just listening to the History, Law, and Justice podcast with your host, Michael Buckner. Thank you for your attention. If you have any questions or feedback on this episode, Michael's contact information is included in the description box. Citations to sources used to prepare this episode are also listed in the description box. Finally, don't forget to click on the link to subscribe to receive the next episode of this podcast. Remember to let history serve as your roadmap for future success.